interest litigation? Why don't they give speeches against judicial activism? Yeah, why do the politicians go along with this enormous expansion of judicial power? Why isn't there a backlash? Why isn't there Theodore Roosevelt in India who says, I'm going to pass an amendment, or I'm going to appoint more judges? Yeah? Why are politicians so willing to accept this enormous rise of constitutional power in the hands of the judges? Yes?
I don't think it's entirely true because of the question of the collegium system being very active recently, wherein they talked about the tyranny of the unelected over the elected. So this is a counterpoint to the point that you're making. Therefore, they are wary of the judges appointing themselves and having too much of a control, so to say. But yeah, I think they use it as a sword and a shield that you are mentioning. And I think to that extent, maybe they use judicial review on certain things, like 2G case is also very famously known for this, wherein the Manmohan Singh was, questioned for certain orders that he passed, and A. Raja in the same case. So it's being used as a sword by Subramania Swamy in these cases.
Okay, yeah. I really like the way you're putting it in terms of a sword and a shield, right? So when you are in opposition, you're out of power. Constitutional judicial review gives you, it's like a sword, right? You can poke the government, you can poke them to go in this direction or poke them to go in that direction. And at the same time you have a shield, and you can say, you can't change the laws in relation to party symbols or electoral rules. Yeah, you can't do this now unilaterally, because if you do, we will take you to the Supreme Court. Yeah, so it's a shield as well as a sword. Okay, and what this graph essentially shows you is the percentage of seats a political party has in the Lok Sabha. There are other indicators of political competitiveness. There are the state elections and everything. But I think the defining feature of the competitiveness of Indian democracy is that as a politician, you know you're going to be out of power at some point of time. And I think, right, you're saying, yes, they're coming after the judges with judicial appointments and the collegium system. That's true, okay? But it took them a long time to do that, right? From 93 to almost 2014-15, right? Okay, and I think there is a single bill that was introduced either in the Rajya Sabha or in the Lok Sabha as a private member bill against public interest litigation. Okay, and there are so many instances of Indian politicians encouraging the Supreme Court to make a decision. Can you think of some of those?
Political tie-ups to form a coalition government, and in case there is any dispute, the matter is taken to the court only for resolution. So that is one thing. Second one is with regard to sharing of the resources. So there also, in case there is any dispute, the matter is taken again to the court. So the best example is the sharing of Satluj Yamuna river water in Punjab and Haryana. So the Punjab government has defied the order of the Supreme Court. So it has begun in litigation. So taking the matter again to the court. So it is subjected to judicial scrutiny again.
I'm sorry. Ways to go by Supreme Court, for example, in case of Arunachal Pradesh, the 2K government came back to power because of the court decision, where the Supreme Court said that the governor's direction to the assembly was unconstitutional. So here the ruling party probably was in an advantageous position to retain power. So these are few reasons why they go by, they don't mind Supreme Court having more power or judges giving more power to judges. But on the flip side, since in case of India, we strike a balance between parliamentary sovereignty and judicial supremacy, and since ours is a parliamentary form of government, although we don't have parliamentary sovereignty of UK type, still then there in some corner of our mind, the psyche of the parliament, the fact lies that a judicial decision which probably will not be, if it is not palatable to parliament, at one point of time can always be overridden by means of a parliamentary law. So, as long as it appeases them, and as long as it serves their purpose, they really don't mind rise in power of the judges.
And that's another great point, because what you have now said is the boundaries of judicial review, what the judges can do, are still determined by the other political actors, right? So they still don't want to create a backlash, so they have to stay within the realm of what powerful politicians want, and they have to stay in the realm of what the public wants, right? It's very hard to find a judgment of the Indian Supreme Court that really outraged the Indian public. You know, it strikes me as a court, I don't want to call it populist, although I know some Indian scholars have, yeah, but it strikes me as a court that really knows what the majority of the people wants, yeah, and I think we'll come back to this when we talk about 377.
So I think the Bommai case is a very good example of the insurance model, because all parties are interested in having an arbitrator that would then ensure that the power of the central government to derail state governments doesn't really get abused. So I think everybody was interested in having an arbitrator, and the Supreme Court really played its role well there. It said that I will not decide. Yeah. Although I understand that this power can be unconstitutional, but it will again go back to the floor of the House. So in that sense, it puts the ball back in the political arena. So I think that again is a very good model of using your power, but using it very judiciously.
Yes. And can I just say an interesting example where the Supreme Court has been very aggressive is Association versus Democratic, Association for Democratic Reforms. Yeah, where the Parliament came back and overrode the court, right? Isn't that correct? And then the court struck down the Parliament saying you can't override us because of basic structure and judicial review. And I think it's essentially because there's this overwhelming support for anything that looks like anti-corruption measures enforced by the Supreme Court, and powerful support by the Electoral Commission. Right? So if you have Electoral Commission and Supreme Court, both non-representative institutions, yeah, but if they gang up, they can form a really powerful force. Yeah. Yeah.
Just to add to what Dr. Vasanthi ma'am said, sometimes the Supreme Court has again thrown back the ball. Like in the interlinking of rivers in the 2012 case, they said, we have a limitation, you know, we cannot make policy decisions. So left it to the center and the state, okay, you come up. Or you have the Kaveri dispute again, they play a very important role, but again saying, you know, state, water is a state subject, so you all take a policy on that. So sometimes, you know, throwing it back and saying, okay, you come up with this.
There's an interesting example for this for comparative law, from the comparative law perspective, and that's the Judicial Yuan in Taiwan. I know this quite well because my PhD student wrote on this a whole chapter. And a lot of the judges in the Judicial Yuan are strongly against the death penalty. Yeah, they have written books against the death penalty, they have given university lectures against the death penalty, and so on and so forth. But when they had to decide a case as a judge sitting on the court, they voted in favor of the death penalty. Because they felt it's their duty, if 95% of the population is pro-death penalty, to stick to public opinion, right? And that's why the Judicial Yuan is such an exceptionally powerful court, because it has never angered public opinion. The one time it is always passing judgments that tells the public politicians are really terrible. Yeah? That's super. That's like the Indian Supreme Court in the 1980s. Everybody should have enough to eat. We want clean air, better education, right? I mean, it's not controversial. Whereas with the dam, when they had to decide the height of the dam, it was a win-lose situation, right? And I think they learned their lesson, and now they're staying away from water. Yeah? So you have this example from Taiwan. There's another example in Taiwan. There was a litigation trying to force the Supreme Court to decide whether Taiwan is an independent country or whether Taiwan still sticks to the one China fantasy. Right? And public opinion in Taiwan is split on this, 50-50. Do you think this acutely aware Constitutional Court in Taiwan does in such a situation? where such a controversial issue is brought before them. What would you do if you were a constitutional court judge?
Whatever gives you more power. Yeah. So decide whatever gives you personally more power as a court.
Okay. But half the country wants, sticks to the Kuomintang that says it's one China. The other half says, I really would prefer Taiwan to be declared as an independent country and move on. So it's split in the middle. So how are you going to generate massive public support? Or what are you going to do as a constitutional court judge? You don't need to know the Constitution, right? Just think it through with this strategic model of how you're going to build.
To give a decision making Taiwan a part of China, and a decision to be taken after 20 years by calling for a referendum or something like that.
Okay, that's great, you postpone. And that's more or less what the court did. The court, for the first time in its history, says, oh, this is a political question, and we don't decide political questions, right? Has never stopped them from deciding political questions in other cases. So there are all these factors going into the explanatory models of political scientists or economists or psychologists in terms of thinking about Supreme Court judges that are very interesting for lawyers to study. Yeah, we'll come back to why the law matters still very much now in the second half of the lecture, right? But the first thing that we've done so far now is we sort of deconstructed this idea that we need the constitutional text and a specific jurisprudential method, and that's the only way to think about constitutional courts. Yeah, so the field really has moved on. I'll give you one. You have another.
What about the Brexit in UK? So the court did rule against the referendum, and I think it's still pending with the Supreme Court or the House of Lords.
The High Court has said Parliament has to be...
Isn't it against the popular opinion?
My popular opinion is split right in the middle, right? And the court hasn't said Brexit cannot happen. The court simply has made it more difficult for the government to declare, to make a declaration under Article 50 of the European Union treaties. So now that the government first has to go to Parliament and ask for a vote before they go and make that declaration of leaving the EU. So it just hasn't made it more difficult. It hasn't decided the issue one way or the other. Okay? So that's another way a court can delay, and then maybe the judges are hoping if you delay this thing for 5-6 years, there'll be a second referendum. Okay? I wanted to give you one more example from Germany. In the German constitution, there was an article that Germany can never ever be part of military action outside German territory. Right? The only thing the German army can do is defend this territory. It can't leave it. And that worked very well for Germany until Yugoslavia. In the first Iraq war, Germany said, sorry, we have this article in the constitution, but we'll give a lot of money to the US, and the US was happy, and in Germany there was no political crisis. Then you had the war in Yugoslavia, the civil war, and NATO asked for German planes with a specific radar equipment to take part of this military action. And the German government was a coalition government of the Conservative Party and the Liberal Party. Okay? So how did they use the Constitutional Court? The Conservative Party ordered the military to take part in the exercise, and the Liberal Party filed the litigation in the Supreme Court saying we must know whether this is constitutional or not. So the entire debate now is not, should we take part in this war or not? The entire debate is now, what is the Constitutional Court going to decide? Okay? And then, of course, the Constitutional Court comes back a long time later and says, well, it's a peacekeeping international coalition mission, and it's fine if Germany takes part in these. Right? So none of the politicians had to invest their political capital in terms of saying, this is what I want. Right? But it's sort of a hot potato, and they tell the judges, please come and sort of grab them and take them out of the fire. So that's another thing that you see constantly. I think you can see it very well with disinvestment in the Vajpayee government, when one wing of the BJP party files a public interest litigation in favor of disinvestment, while the other wing of the party, especially in the cabinet, opposes it. Yeah? So there's a wonderful article on this by Manoj Mate, which I will also put up on your reading. About the insurance model. All you have to take away from this is that the origins of judicial power can be rooted in the political system itself. Yeah? So there are certain structural changes in the political system that open up a space where judges can become active, and it can even be that politicians are inviting judges to make decisions for them, sort of as a blame avoidance strategy. I can give you many examples for this. Egypt and the role of Sharia law. Politicians did not want to deal with this, so they leave it up to the Constitutional Court. Pakistan creates a Sharia appellate bench and a federal Sharia court. Yeah? So now the politicians don't have to give you a clear answer about the relationship between reform, their ordinances and legislation, and Sharia law. They leave it to the judges. It's also lovely because it's very confusing, because you don't know who has the last word. Is it the federal Sharia court or the appellate bench? Or is it the Supreme Court? Yeah? That's all very fuzzy. So everybody can imagine everything. And you postpone the dispute. You postpone this ultimate decision to be made. There are other reasons for institutionalizing constitutional judicial review. This is the work by Mustafa on Egypt. That's interesting because it's an authoritarian regime institutionalizing constitutional judicial review. And this is done to signal to the international investment community, your property rights are going to be safe. Yeah? We have a constitutional court which protects the right to property, and you can come and invest here. Yeah? Because the Nalsar government was a socialist government and had done a lot of expropriation and nationalization programs. So in order to restore the trust of the international community that you can invest in Egypt, they institutionalized this court. Also going to put up this article by Shapiro on political jurisprudence. You can see that these debates are really quite old. They come back in different terms. Sometimes we call it judicialization, sometimes we call it juristocracy. Yeah? But essentially behind it is this wonderful way of how Shapiro is putting it here. You move away from the study of law to the study of men. Yeah? And today he would write, of course, also women. Yeah? But that's 1964. Okay, so now we have a better understanding of what politicians want and why they're happy with constitutional judicial review. And now we have to decide what judges want. Right? And we are going to try and look inside the judicial mind. That's difficult enough because they don't tell us. Maybe they're not supposed to tell us even. And it gets even more difficult because the judge has to navigate bench politics, right? He needs or she needs a coalition of other judges to pass the judgment. So how do we think about this? Again, they are the legal realists. But in America, in the United States, you have this powerful movement of behavioralism from the political sciences. And you have Pritchard and Schubert's path-breaking work on the US Supreme Court by counting cases. Yeah? When is there judicial dissent? Why is there more dissent? What does it mean? So they're just counting various variables and adopting a purely quantitative approach to thinking about patterns of Supreme Court decision making. Right? So that's an entire new way of looking at the case law. You also have psychologist models, and we'll get into this in a minute. And you have the attitudinal model coming out of behavioralism, and you have the strategic model, which we've just discussed, and we're sort of now closing, and now we're taking a closer look at attitudinal model and psychological models, just to understand the judges. Okay. So the students of Schubert Siegel and Späth have developed a model where they are thinking about constitutional court judges in terms of their policy preferences, right? So they're not interested in what they tell us about legal theory. They're not interested what they tell us in terms of constitutional interpretation. They're simply looking, is he pro-states' right, anti-states' right? Is the judge pro-abortion, anti-abortion? Yeah? So they have these various variables for thinking about whether a judge is liberal or conservative. And they rank them. And so they only do this with numbers. So the book then looks like this, right? What are the values of the judges? And how do they vote in specific cases? This is also called the computer model of judicial review because they are predicting judicial decisions. And just 1 minute. They're predicting, and when Bush versus Gore, the election dispute about Florida, came to the US Supreme Court, they went on record and they precisely predicted how the judges would vote. And they could predict that the judges who were pro-states' rights and should have supported Florida in the recount would vote pro-Bush because they're conservative. And they predicted that the judges who usually are not so much in favor of state rights would decide for Gore. Yeah? And so that's a remarkable result. And there's a lot of scholarship going into this. I don't think you can replicate this for India. Some scholars have done in the 1980s. But I think India is too complicated for it. Because here the judges are on the court for 20, 25 years. They decide 60 to 80, sometimes 90 cases a year. Can you imagine? Only to have read 90 cases. So I think India is a very different type of court, and we'll get to that towards the end of the lecture. You had a question, please. Yeah, they're assessing it on the basis of a newspaper article, other things they know about the judges. So and judgments they have passed when they were judges before, right? And also in the past, some of the judges were politicians. And so they have a method for determining the political preferences the judge has, and then they tell you why they're going to vote this way, right? So it's not reasoning backwards. Yeah, they're not saying, oh, he voted conservative, and that's why he must be conservative. It goes the other way around. And it's a good question that you're asking. I urge you to read the book by Linda Greenhouse on becoming Justice Blackmun. You must be able to get it as an e-book for a very low price. She's the New York Times reporter on the Supreme Court, and I think she's really the role model globally for how one should do newspaper reporting on a court. It's absolutely breathtaking, and you can see the depth with which Americans are studying their constitutional court. Yeah? So Justice Blackmun, he kept a diary since he was 9, and he writes everything in there. And she has all his files when he was a lawyer for the Mayo Clinic. And when he was writing the judgment in the Roe versus Wade decision on abortion, it's actually much more from the perspective of the medical, of the doctor's perspective, right? So she puts all of this in an absolutely wonderful context. And again, I think you can't replicate this for India because you just don't have that sort of data on your judges. Yeah? I mean, you could start it, but even if you started, your judges are at the Supreme Court for, on average, 4 to 5 years. Yeah, then they're gone. Here, you invest into the study of a judge because a judge can sit from 1935 to 75. Right? So there's a very long time periods, the longue durée, and so it really makes sense to go into such detail and look at also how political preferences of the judges are evolving. So you can see Scalia gets more and more conservative, right? Who just died, and this yellow line here shows you the average of is the court conservative or liberal. So it has nothing to do with law anymore. Yeah, but extremely powerful and even aiming at a model for predicting cases. Now, I want to look at the judges again now from a more legal perspective again. Okay? And there are 2 articles here which I will put online. One is Baum, What Do Judges Want? And the other article is by Posner, who is a professor in Chicago as well as a circuit court judge, who writes, what do judges maximize? Yeah? Okay, so what do you make of these various variables, and how does the law now come back in judicial decision making? Why is it not useless to study law? Yeah, why do the judges take the law seriously? I mean, if you speak to Supreme Court judges, they will always tell you they go and find a legal argument. Yeah? I spoke to Dieter Grimm, who was Chief Justice of the German Constitutional Court at a conference, and he openly said they're reasoning backwards often, yeah, that they have the result and then look for the law. Cardozo also wrote this in his book. Yeah? But he said they're looking for the law, and if they cannot make a reasonable legal argument, they will not make the decision that they actually would like to make. Yeah? So that seems to be another constraint. So how does this fit in here? Why do judges, what are judges maximizing? What do they want that makes the law relevant again? If you were a Supreme Court judge, what do you want? Did you become a Supreme Court judge to get money? No, right? Then you would be a senior advocate. Yeah? Did you become a Supreme Court judge to be lazy? Yeah? You just want to hang out and don't do any work? No, they work very hard globally, yeah? Exceptionally hard. That's what you want as a Supreme Court judge? Ah, okay, yeah. Okay, but once you are at the court, what's your perspective on what you do? Yeah? Yeah? Okay. Okay, so then your goal is to stabilize the legal system and tell the high courts what to do. Okay, yeah. So then you're guided by purely legal considerations. You're not guided by your policy preferences. Which the attitudinal model says what you want to do as a judge is you want to maximize your values. Right? So if your value is very, very free speech, every time you have an opportunity to shift the law in favor of free speech, you will do it. Yeah? You will work for that. Yeah? But Baum and Posner we should take particularly seriously because he is a judge, they tell us there are other factors at play. I mean, what else could you be maximizing as a judge? What do you want? Who do you speak to? How do you want to be remembered when you die? Okay, yeah, so you're back to power, all right. Okay, yeah, so the purpose, what you think is good for society, okay?
If 70s to they expanded the fundamental rights. So they were trying to move from a dictatorial type of mindset in India. The procedure established by law was just not meant to be a dictatorial form of government. We're trying to move towards some moral values. We are not just a society that is run by the procedure established by government. We are trying to invite messages into it.
Okay.
That's why if I have to put people just, I want my law to be moral. Not because you want to follow it, because I want to follow it.
Okay.
That's what I want to invite in that.
So again, it's your inner values, your perceptions of morality. Okay? So then if we want to understand a constitutional court judge, ideally we should know what these values are. Yeah? They either should tell us or we need another way of finding out. Yeah? Okay? So that's again a value. Okay? Yes? Sorry, that.
So I think I would primarily go with the UK judges' stance, wherein they believe in a lot of brevity and precision.
So if you actually look at the earlier constitutional judgments, whether given by Justice Vivian Bose in the early 1950s of the the Indian courts, Supreme Court, so you see that a lot of those judgments didn't run into 300 pages or 400 pages for that matter. But at the same point of time, they did make a lot of sense. And that ideally was a sort of judgment which we took into consideration from the UK system. So I would probably go with a lot of brevity and precision. And depending, that will be with other allied factors like the prevailing social, economic, political and cultural circumstances, because that is something which is going to be an integral part of you giving a judgment. So many times I personally would be of a different opinion when it comes to, let's say, I'll just give you an example. So when I talk about freedom of speech and expression, now sir, I also believe in the test wherein you cannot go to an extreme level and denigrate or degrade a particular religion for that matter. So I would be of a particular opinion of that sort. But at the same point of time, sir, I think that when you're giving a judgment, you cannot be purely considerate of only what you feel like or what you want. So I would have to take into consideration with respect to what the community or the circumstance in the society itself wants. So I would say I would go for a balance of both. And as a matter of fact, the Constitution or the tools of Constitution interpretation takes into consideration all of these factors. So I would believe in this.
Okay, yeah, but again, you would say that if you were a Supreme Court judge, you would take constitutional interpretation very seriously.
I would, sir.
You would, okay.
Yeah.
So in my view, I think I'll try to deliver fair justice to our people, plus I would try to, as a judge, to advise the political parties to make laws which are in interest for population at large, not to which are monopolized at their own interest. So helping the politicians to make the laws for the benefit of people at large or societies.
Okay, yeah. So again, your sincere belief, this regulation is a good regulation, that's why I'm going to implement it.
Yes.
Yeah, and then you look at legal argument.
So if there is any laws which are inconsistent with our own rights or given by the Constitution, that may be which our present the law is doing.
Okay, yeah. All right, there's one more.
So I think judges have their own personal experiences, their background from which they belong, and after analyzing the facts of the case, they themselves took decision they are influenced by their own personal backgrounds. And then they analyze the law and interpret that law in such a manner that it fits into the case. And then they say, okay, the law is also, they interpret law in such a manner that the decision which they took is right, and even the law is saying the same thing.
Yeah, so, that's a very important point you're raising, because this, if you take background into account as a factor in judicial decision making, that's a strong argument for diverse judiciary. Yeah, diverse in terms of gender and particular communities.
If I may add an example, Justice K.T. Thomas, he's a death penalty.
One more? Okay. Now, who decides whether a judgment is good or bad, right? I mean, coming back to Humpty Dumpty, who's master, right? So, what's the currency? Yeah, I mean, let's go to personal standing, right? I'll ask you to call it prestige from now, because there's a new body of scholarship now emerging very fast. Yeah, Epstein has changed her point on the strategic view of judging. She's written a big article in 2014 saying we were wrong, more or less, which is great if an academic writes we were wrong. And she said we have to take this element of prestige much more seriously. I think Tom Ginsburg was in Delhi and gave a lecture on judges and prestige. So can you maybe rephrase your point in terms of prestige, and where do you get something like prestige or standing or honor or respect? What are you maximizing then as a judge?
Recognition as a constitutional authority, like you might be considered the greatest judge say P.N. Bhagavati or a judge who's quite memorable.
Yeah, so you are constrained actually, your legal reasoning, it can't be totally out there, right? You have to correspond to what the legal community thinks of you, right? What do professors at Nalsar think of this judgment? What do the students think of this judgment? What does the Bar Association think of this judgment? What do the journalists think of this judgment, right? So over a long period of time, the meaning of these words fluctuates tremendously. But if you look at shorter periods of time, there is a sense of constraint through a legal discourse that's not really maintained by the text, right? The text is dead, but there are many readers of this text. Yeah? So it's not the author of the text that matters, it's specific types of readers. Yeah? And some readers matter more, and some readers matter less. So that's what he means here by personal standing in the legal community and then also in the community as a whole. Right? So in that... Yes? Yeah? Okay. Yeah, he had a lot of prestige from the communities he cared about most. Yeah? Okay. Yeah, like Earl Warren, politician turned judge, Roman Herzog, politician turned judge. Yeah, that happens. I think he was Minister of Interior, Kerala, no? Yeah. Okay. Right, you have a more discursive model of thinking about what the right decision is. Right, that's why you have a bench of 5, which has a discussion, and so you also listen. Right, you listen to as many voices as possible. That's why you invite friends of the court, amicus briefs. So I think the duty is to have a deliberative process. Yeah, and if a judge shouldn't want to be on the headline of on the front page of the Hindu, right? That should not be the motivation.
Yes, sir.
Yeah, but if there is a sense of constraint in terms that the judge wants to make an effort to communicate to the legal community and wants to make himself or herself understood.
Yes, sir.
Yeah, I think that then is where, again, the legal discourse and the law as a constraint comes in a valid fashion.
Sir, if for example we take Krishna Iyer. Krishna Iyer was known as people's judge, and that's something like popularity and respect. Wasn't he influenced by the popularity of himself as a judge, and couldn't that have affected his judgments regarding human rights?
That's something I'd like us to discuss towards the end of the lecture, because and you have to tell this to me, right? I don't know the answer, but as I understand the Indian Supreme Court, it's really an English language institution, right? It's one of the few websites of the Indian government where you don't have Hindi immediately, okay? I don't know, have you read Keshwananda in Hindi or in Tamil or in Bengali? Does it exist? Has somebody translated it? Yeah? And how many people in India are so fluent in English? Anyway, reading a court judgment is a pain, right? But then, how good do you have to be in English to, right? So, who are the judges writing for? There's a wonderful article by Bakshi where somebody criticizes Krishna Iyer in a really dramatic fashion, and so he responds and he says, look, who understands a judgment in English anyway, right? Who are they writing for? So that's a point we have to discuss later on. And again, I think here the Indian Supreme Court is very special. Yeah, I understand they can't be a multilingual court because it's too complicated. I understand that. So we're going to go into a comparative example towards the end, and then again you can do a little bit of group work exercise on that. Yeah. And you get good feedback, right? People are telling you, oh, this is great. Then you will continue on that path, right? It's again not a purely legal argument, but it explains to us the structural forces that make the law stable, yeah? At least over a period of time. Please don't forget, international community, there is a global movement in constitutional courts and in scholarship on LGBT rights. And if you look at Article 377, look at it from these perspectives, right? These judges go to international conferences all the time. They're publishing it now. Pick up the Supreme Court annual report and look how much the Chief Justice travels and wherever he speaks, right? And wherever they speak, they will be asked about this thing. Yeah? It's going to have a huge impact on them. And then also you can use your strategic model and you can think, are they going to be bold enough? Are they going to delay it forever? Or at some point of time, are they going to be bold enough and to say, significant sections of the Indian population will be against this judgment, but we're going to go for it. And I don't want to spend too much time on that. Again, another force that is not directly visible in the law school immediately, which are the forces that actually set a constitutional court's agenda? Because the judges don't pick and choose their cases. There's suo motu here or there in India, fine, but that's irrelevant statistically speaking. But most of the cases are coming from litigation efforts. Litigation efforts from the People's Union of Civil Liberties, other NGOs, cause lawyers, right? So there are organized groups which systematically use courts to bring about social change. So there's another level of scholarship here which is very important, which we can think about is, are courts actually the right institution to bring about social reform? And there's a really wonderful book on this, again by, I think, a political scientist, Gerald Rosenberg from the University of Chicago, and he has looked at this in the context of desegregation in the United States. Because the world's most celebrated Supreme Court case is Brown versus Education Board of Topeka, right? And we all think it's the Supreme Court that did it. Often we forget that the Supreme Court didn't demand the enforcement of the order straight away, but gave them some time. Yeah? But for the world community, also this was very important as a Cold War issue. But was it really the Supreme Court, and how effective was it? And what were the sources of political support, the support constituencies on which the Supreme Court could build? And would he have done it if those support constituencies would not have been there? So Rosenberg looks at a number of indicators. He looks at when does enrollment of black school children in white schools actually pick up. and it picks up very, very long after the judgment. He looks at civil rights demonstrations. When are they happening, and when does the judgment come, right? Does the judgment come before the political climate has changed, or does it come after the political climate has changed? Yeah? So these are important indicators by which Rosenberg concludes that processes of reform always have to work out as a political and social issue first, and only then comes litigation. And I'll just show you this slide. He calls it the lure of litigation, right? He says, or you waste an awful lot of resources, and all you'll achieve is a very timid formulation of your policies, right? So I also wanted to give you a perspective of one book that is explicitly anti-litigation. And the second edition also picks up the issue of same-sex marriages for lesbian gay couples, and he recommends to first seek a political solution. There's another interesting book in that sense of generating public support for cases that essentially are judicial policy making and judicial lawmaking. Judges now more and more take into their own hands how they communicate the judgments, right? They don't leave it to the journalists, they don't leave it to Twitter, they don't leave it to Facebook. They have their own public relations managers now. They have their own website, they give out a newsletter where they have summaries of court judgments. They're telling us what is more important than the other cases. Yeah, so this is again an entirely new way of Supreme Court organization and of judges engaging with the public. There's a wonderful book on this on Latin America and which courts have websites. Is it selective promotion of cases? Is it universal promotion of cases? Which cases are getting published? Yeah? So also think about all these questions of social organization behind an institution, legal knowledge that you read. Yeah? Why do you read Judgment A? To aspect of constitutional law scholarship that is taken very seriously. Okay, I'll just skip this. So what we have done so far is judicial review as a dependent variable, right? We have said there are all sorts of factors out there that determine whether a court goes this direction or that direction, and so we brought a whole new set of variables to the study of the law. Litigation support groups, values of judges, legal community, discourses within the legal community, yeah? Separation of power games, strategic models of judicial decision making. Yeah? So these are all interdisciplinary methods for looking at constitutional courts in a new way. I'll give you one last example before we go into court organization about the importance of you, right, as lawyers. And the example is the downfall of the Weimar Republic 1918 to 1933. After 1918, Germany becomes a republic. Elections are being held regularly, right? You can see there's an election 1919, 20, 24, again in 24, 28, very unstable, large coalition governments, right? So there's a lot of elections going on. There are massive political forces at work in the country. There are radical left-wing positions, radical right-wing position. There's an army that's dying to have revenge, and already in the 1920s starts to prepare for the next war. Yeah? So there's a lot going on. I don't want to give you the impression that judges could have just stepped in and could have saved that. But judges in Germany were very much blind on the left eye and let a lot go on the right eye. And a wonderful example for this is a case from 1932. Now, here's a reminder that the Nazi Party never actually gained 50%. 43.9% here is the best result they had, and there was another power checks and balances factor in there. Germany was a federal state, and the state governments mattered, right? So you can see here Prussia, the biggest state. It's a very asymmetrical federation. And at that point of time in Prussia, you have a left-wing party. You have the Social Democrats. So that, if you look at that, they're winning here in terms of the national results, but the biggest, most important state is in the hands of their political opponents. Okay? So what do? The president of Germany declares a state of emergency in that state, and the government is out of power there. So the Social Democrats are out of power there. They go to the German Supreme Court, the Staatsgerichtshof, and the big German constitutional theorists are there in court. Yeah? Hans Kelsen is an observer in Vienna, but Hermann Heller is there and Carl Schmitt is there. So they're fighting out this case, and as you can imagine, the court sides with the emergency measure and declares the measure valid. And so an important political opposition to the rise of the Nazi Party is taken out of the game by the judiciary. Yeah? And it's very common, it's very rare for courts to step up to a government during a time of emergency and say, you're wrong. Yeah? That doesn't happen. They sort of go into hibernation. Yeah? Come back to us when the emergency or the war is over. That also was the case in Pakistan, but I think it's important to point out what has happened there in 2005, 2007. So you have a number of phases of military rule. You all know that. 1958, you have the Dossow case. Kelsen in the courts, our Grundnorm has changed. Now it's the military in power. All is well. The military can do whatever it wants. Yeah? Very much in line with the German response to emergency and based on the same author. The Gilani case is interesting because for the first time now here they declare actions taken by the military government as invalid, but they do it once the military is out of power. Yeah? So they don't take on the military. Is that clear? Yeah, that's an important distinction to later on. Musharraf, they say, state necessity. There's nothing we can do, I'm sorry. It's all fine. And now here comes the big change. The story of Chief Justice Iftikhar Chaudhry. Yeah, that's the first time, I don't know of any other case, in which a constitutional court judge has successfully taken on a military dictator and displaced him. The story starts with him approving of Musharraf. He takes the oath in 1999, and again it's state necessity. Then there are a number of public interest litigation which put the judiciary at odds with the military government. And he's then suspended. He asked him to resign, but he doesn't resign, right? So in Pakistani constitutional history, he's the first judge who stands up against emergency powers and says, let's wait and see what happens, okay? So Musharraf puts him under arrest and puts 70 judges under arrest, but he hasn't counted on the strength of the lawyers' movement in Pakistan and the weakness of his own political position at that point of time. So there is massive public uprising in Pakistan by the lawyers, and that's what we call the litigation. So again, it's not about constitutional law. I've shown you now 4 decisions which all go in this direction and that direction in terms of the response of the constitutional court judges to a declaration of emergency. It's about the specific political context and the support constituencies the Pakistani Supreme Court judges can rely on at that particular point of time in 2007. And it turns out to be very strong. The 5 leading lawyers of Pakistan go to the Supreme Court and argue the case for the Chief Justice. Yeah? The Bar Association gets behind it. Hillary Clinton makes an international declaration. International Bar Association is on board. These are all things that didn't happen in 1932 in Germany, right? And Germany's lawyers in 1932 were really, really right-wing. Yeah? And that's because it was a Prussian system of legal education in which you could only go ahead if you came from a conservative and very rich family. There was a very selective decision of judges. You had to be state prosecutor for 12 years and you wouldn't become a judge if your political preferences were not very, very much to the right. Yeah? So here's your variable that explains to you why things are suddenly different in Pakistan in 2007. And for the first time in the history of that country, you have a democratic transition of power. So I urge you to read the article by Gyasi on the lawyers' movement. Scholar. You also have political parties weighing in. There you can back to your insurance model of judicial review. So it's a wonderful case study for you to apply all the things that you've read. There's also a seminal article by Bakshi here where he... Okay, so that's the importance of the litigation support structure. The book which has framed this really well is The Rights Revolution by Charles Epp. Again, it's partly quantitative by looking at cases, and he can show to you that all the American case law in the 19th century is mainly about contract and is mainly about property rights. There's nothing there about fundamental rights litigation as you know it. Yeah? That only starts slowly in the 30s, 40s, and then takes off in the 50s. And Epp tells you the reason for that is the litigation support structures, American Civil Liberties Union, legal aid reforms, and you can see the first women's rights cases are coming up only in the 1970s. Yeah? So it's not a change in the constitutional text, but the agenda of the court changes dramatically. Again, as lawyers, that illustrates to you to think about your role in the legal complex, legal academia, legal training, legal education, funding of legal services. Yeah? So this whole gamut, civil society, the legal complex. And it shows you the impact that you have by shaping the agenda of a constitutional court. And this, of course, is a very powerful example of that with the under-trial cases. Yeah? So again, you can relate. Epp's scholarship is on Canada, New Zealand, Great Britain, also India, and the US. Again, from comparative scholarship, you can isolate the variable that you think is most relevant for shaping a Supreme Court's agenda. All right, now the last group exercise I wanted you to undertake is to think about the organization of a constitutional court. How much time does a judge have to write a judgment? Is there a law clerk? Yeah? Is there a research assistant? What's the status of... Are they allowed to use foreign judgments? Yeah? What are the working conditions? Is there a lot of fighting going on in the court? Yeah? Does half of the judges not speak to the others? And so on and so forth. And I want you to think about this especially in terms of time and resources. This is the number of public interest litigations filed in the Indian Supreme Court. These are the number of petitions they accept. Yeah, I think Muralidhar says only Hindi and English petitions are accepted. Yeah? But I don't know how the PAL cell works. If you do, please come to me and tell me. Or maybe we can set up a research project on that. And these are the number of PAL cases that are actually published. Right? So that's all the stuff that's going on in the registry. That's the stuff, that's the amount of cases that are getting decided. And that's what's getting published. So it would be interesting to see the process. How do they pick them? Yeah? Which ones do they decide but they decide not to publish? How does that work? And which ones do they pick and they decide to publish? Is there something they're hiding? Should they be allowed not to publish a decision? Yeah? On the other hand side, if they publish every decision, can we handle the amount of knowledge they produce? And so on and so forth. Now you might think this is particular to India. No. There's another court which has similar workloads, Brazil partly, in labor law for instance, but also the European Court of Human Rights, right? So that's the jurisdiction of that court. Yeah? So that looks similar to India in terms of size. That looks similar, at least in terms of population, 820 million. Yeah? 47 different judicial systems. But the court de facto functions nowadays, since 1991, de facto it functions like a constitutional court for human rights. Distances is similar to India. Moscow to Strasbourg is about 2,173. Right? So there are good reasons to compare this court. Also, it's a multilingual court, 35 different languages. Right? So here you have an institution where the task for the judges is as enormous as the task for an Indian Supreme Court judge. So what do they have to deal with? Almost nothing until they changed their rules in the early 90s, and then the lawyers are kicking in, right? They learn we can go to Strasbourg and file a case, and look at what's happening. 14,000, 20,000, 30,000, 50,000. And they don't know what to do. And there's no public interest litigation here. They all have standing. Yeah, they're very strict on standing. Still the floodgates of litigation are open. Why? Because it's 800 million people. And here it's much, much more than that. Yeah? And it's going to be much more. You have one of the lowest litigation rates in the world. So if you think the Supreme Court of India is busy now, just wait what's going to happen in the future. There is no way this institution can survive in the long run. And there has to be dramatic reform at some point of time. It could be docket control, could be multiple courts. These things have been discussed from a very long time, but at some point of time, things that cannot go on forever, they don't. Yeah? And what does it mean for the rule of law if a judge spends 2 or 3 days a week just deciding on admissions? Is that, we haven't talked about that at all. So what are these judges in Strasbourg doing? And if they're not citing admissions, then who is? Yeah? Frankfurter was the last judge at the US Supreme Court who read every case that came because he said that's not the function of my clerks. I must be the one to make that decision. So that's sort of 1930s, 1940s. Yeah, maybe. Yeah. And maybe the workload was just about manageable, and then they introduced docket control, I think, in the end of the 40s. Yeah? But they also had about 1,000 cases. Since they have docket control, they decide very little, actually. Okay, so here you see the numbers for India, total number of cases. And here you see how many cases come to such a big court and how little actually gets decided. Just about 1.44 of the applications lead to a judgment. But still you have 1,000 judgments. Now you are the law students. Can you handle to read 1,000 judgments a year? Yeah? Okay, maybe some of them are, not all of them are on freedom of speech, but how are you able to handle a jurisprudential output of such a magnitude? How do you do it? And what does it mean for the type of court that you would like to see in New Delhi? It's very similar in India. Between 1,000 and 2,000 page judgments a year roughly are being published. And another thing is, in India, as well as the European Court of Human Rights, they try to solve this problem by becoming bigger. More and more judges, yeah, deciding more and more cases. So that leads to a tremendous fragmentation, I think, of bench composition. Benches are becoming smaller and smaller. I've done this research project on all the reservation cases decided up to 2010. You can see at the beginning it's 7 judges, 5 judges, 5 judges, and now it goes down. Now bench composition goes down, 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 down. Yeah, so most of the cases are no longer decided by more than 2 judges. And if you put this in the context of a larger court, the judges no longer speak for the court. Right? So the average bench size goes down. But the number of judges as being representative to a court with now 31, if you're 2 out of 7, you are more representative than if you're 2 out of 31. Yeah? So that's another issue I want you to think about. And think about it like this: small is beautiful. Take an economist's advice. What is the right size for an institution? Yeah, if you're now thinking about institutional reform, and how would you like the Indian Supreme Court to be set up? What about the issue of languages, workload? Yeah, don't think about judicial appointments. Yeah? Just think about the very, very practical issues. How does a case come there? Yeah? How much time is to be decided? And do we want a court that publishes 4,000, 5,000, 8,000 judgments a year? Yeah? What does this mean for the rule of law? Does it make the law predictable? So small must not always be good. At the same time, bigger is not always better. And the example they give is, if you had a hamster baby, it doubles its weight every week until puberty, right? Now, if you did not stop its growth, after 1 year, it would weigh 9 billion tons and consume the entire annual grain production of our entire planet on a single day, right? So there is a reason why a hamster at some point of time stops growing. Now, for the Indian Supreme Court, you saw it growing, 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 growing. Yeah? I want you to think about, when should it stop? How should it stop? Yeah? Think about the social organization of the court, and think what this means for the case law that you're reading. Yeah? And then, oops, that's my conclusion, giving it away. And then we have the final discussion. When you're done with that, again, get together in bus groups and come up with and make the link between the social organization of this building, the clerks, the infrastructure, the computers, the viruses on these computers, the spying on the computers by the NSA. Yeah? Think about all these things and then tell me how you would like the Indian Supreme Court to run when your kids are going to Nalsar to study law. Okay? So you have about 5-10 minutes and then we'll have a final discussion and then I'll give you some concluding remarks. Okay? All right? So it should get really loud again.